Hello, my name is Wendy Brill, and I am a Social Security disability attorney. Today, I'm going to explain how a judge determines if you are disabled. Disability determination has very little to do with the real world. The Social Security Administration looks only at whether you are capable of doing jobs, not whether you would be hired. Thus, you may have to prove that you are unable to do jobs for which you would never be hired. In some cases, the medical findings about your condition alone will cause the judge to find you disabled. In other cases, the majority, we usually have to prove two items. Your medical impairments prevent you from performing any significant job you've done in the past 15 years, and there are not many other jobs you are capable of doing considering your age, education, and work experience. Think about the jobs you have had in the past 15 years and pick out the easiest one. If you did that easiest job long enough to learn how to do it and earned a minimum amount of money from that job, we have to prove that you cannot do that job, even if we are certain that you would never be hired for that job again, even if the company where you worked no longer exists, and even if the job is no longer available elsewhere. Proving the second item, that considering your age, education, and work experience, you are unable to do many other jobs is even more complicated and opposed to common sense. In many cases, we have to prove that you are incapable of doing jobs that we know you would never actually be hired for. This does not mean that you have to be unable to do anything. In fact, very few people who go in front of an administrative law judge are unable to do any job at all. This is an important point to grasp because one way to determine disability is by figuring out what you can do. Then we can determine whether or not jobs within your capacity exist in significant numbers in the economy, considering your age, education, and work experience. We do that either by looking at a fairly complicated set of rules, or in some cases, we ask a vocational expert. The rules that we use for determining disability apply most directly to impairments that limit your physical ability to stand, sit, walk, lift, bend, or work with your hands. Mental impairments are a bit more complicated. If you are unable to do certain kinds of manual labor, whether because of back problem, heart problem, breathing problem, or some other medical condition, your lawyer will be able to look at the rules and figure out what you need to prove to win your case. These issues can get even more complicated when you had jobs in the past where you learned a lot of skills. The judge will want to know about your work skills, and you must be able to explain them to the judge. How do we go about proving all of this? We do it at the hearing through your answers to questions from the judge and your lawyer. Although your lawyer will remind you if you forget something, it is best if you can answer all questions thoroughly by yourself. I hope you have found this information to be helpful. If you need assistance with your Social Security disability claim and you live in the greater New York City area, here is my contact information.